Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started. Happy Friday to you folks. This is Omar Serrato with the Tilted Lawyer Podcast. And man, what a week it has been. What a week it has been. I had a race with Lauren Knighty that I'm a little disappointed that she's not reveling more in her victory than she is. She's kind of just like dismissed it and moved on, which makes me feel great about my swimming prowess. She's like, oh, that's not even a win that we need to ever acknowledge. So it is what it is. But on another note, I was over here minding my own business. I heard that David Gingras was going to file his latest appellate submission to the Arizona Supreme Court, to which I commented, ask me how interested I am in what he has to say to the Arizona Supreme Court. And the answer was not at all. But he made a video last night and he took some shots. I did watch his video. I even left a comment on his video saying, respect, man. Hey, whether or not I think he's right, I could give a shit about him talking shit about me. But Rachel Juarez, like, why would he go after her? Oh, she's a fake judge or whatever. Bro, come on now. I watched him on Reality Steve's show, basically groveling at her feet, trying to show respect at all of her accolades before she thoroughly dismantled him, molecule by molecule, and their very public debate on Reality Steve's podcast. As for me, long before I had ever, this had ever gone to appeal, the appellate briefs ever existed, I had a phone call conversation that none of you heard about. You heard about it, but you didn't get to, it wasn't all public or anything. It wasn't recorded. It wasn't on my show. We had talked about maybe doing a debate. It just never came to fruition because we just were clearly not going to agree. And I asked him directly. So I remember one of the very first questions that I asked him within the first 5 minutes of discussing this Rule 26 issue was, are you saying that by Echard applying for relief under Rule 26, that somehow supersedes all other pending claims for relief, namely statutory relief? And he's like, yes. And I was like, well, I don't know about that, man. I'll have to do my research. I did about an hour of research about it, and I found like 15 or 16 cases that said otherwise. First, he tried to tell me that some of the statutes didn't apply because this was a parentage case, even though we were litigating in a parentage case. So it was like, I didn't understand. Anyway, I made a whole video about my thoughts before any of this came to light. And it turns out that I've been right all along, even though I'm not an I'm not an Arizona practicing attorney. I practice in California. I practice under the California Family Code. Believe it or not, I am not, well, I guess I am not currently, what am I trying to say? I'm not currently licensed to practice federal law, but here's the kicker. When you pass the California bar, you have the option to just buy that license. Like, you're fully qualified. You want to practice in federal court, then pay the fee. It's like $150 or something like that. I forgot what it was. I've never had to pay that fee because, number one, I run my own law firm. Thank you, Kelly, for the 5. Hey, Omar, tonight is Feral Friday. Can't wait to get feral. Oh, I'm already there. Halfway there, anyway. If you pay the fee, then you can practice wherever you want. Federal court, 9th Circuit, 2nd Circuit, wherever, you know. But most of my cases were in state court. And because I was at the DA's office, I wasn't at the federal DA's office. I was at the state court. When I ended up working for a law firm, we actually had federal cases, but I wasn't doing the federal cases. I was doing all kinds of other stuff that they wanted me to do. I was working on those cases, but I wasn't appearing in court because I was a baby attorney. I had mentors too, and but even then, the majority of those cases were in state court. And so what would be the point of me going and spending an unnecessary $150 or $200 or whatever it is to get my federal license. I'll tell you what, when you go to law school, you learn the federal rules. And I guess the big secret is, I'm not even sure if it's a secret, the federal rules are much simpler than family codes of all of the 50 states and territories. They're simpler. Usually all of the state bodies of law are based off of the federal rules. And it's much easier to just go to the canon of federal law. That's what you learn. When you take the bar, you take it under the federal laws, unless other states have like specific things. But anyway, I learned under the federal rules. So it's not like this big mystery. And guess what? Arizona law, even though I haven't practiced federal law, I seem to know the Arizona family code better than Jingris. And it took me like a whole hour to research cases to figure out that he had deficiencies in his Rule 26 arguments. And so it seems to be Gingris's style that whenever somebody disagrees with him, he's very gracious. This is his approach. This is his pattern. If he thinks, well, he approaches you with kid gloves. He tries to bring you in and rein you in. He wants you to be his friend. And then he's very friendly and he's cordial. And, he probably would buy you a beer or like take you out to dinners. Oh, look at all my rich and powerful friends and look at all these people that I know. And look, I was in Dr. Phil once and this and that. I've been an attorney for 26 years. And he tries to convince you of his prowess as a litigator. And then when he finds out that you're not going to be wooed in by all of that, then he kind of just switches. And, he was very respectful, I thought, of Rachel Juarez at the beginning until she dismantled him in very public fashion. And then all of a sudden, oh, she's not even a real judge. Never mind, she's like Harvard educated. He was literally groveling at her feet at the beginning of that debate. Before I was dead to him, he was like even saying friendly things about me. And so, what's up, Lauren Knighty? How you doing over there in Australia? Hope you're getting your rest, young lady. So that is Jingris's style. And so, but when I watched his video last night, it was very short. It was like 25 minutes. I got to some of his logic. And, he accuses me of not knowing family code or federal laws, even though this is not a federal case, by the way. He's trying to base Rule 26 as the equivalent of federal Rule 11, which it largely is, to be fair, but this is still an Arizona state case. His logic was this. There used to be a safe harbor provision. And then he says he has this lunch. David Gingras says he has lunch with this judge. He says, you know what? In family court, most of the people are without attorneys. They're in pro per. Why are we imposing these federal rules of procedure on these non-litigants or these unexperienced litigants? Why don't we just make it simpler for them? Why don't we just get rid of the safe harbor provision? And then I guess they adopted Arizona Family Code Rule 31 or whatever. And he said that was a thing from, what did he say? 2003 to 2019, I think is what he said. I'm paraphrasing. I'm off the top of my head. I'm trying to remember. If my numbers are off, I'm just saying don't quote me on that. But it was like for a long period of time, almost 20 years, where they operated without this safe harbor provision. And there were policy reasons behind it. And the policy reasons were that most people that come to family court are just trying to get divorced, man. They're just trying to get custody and visitation orders. And sometimes people behave badly. And you know what? These are often cases that are shrouded in lots of emotional turmoil. Jingris said it himself. He said, like, back in 2005, he worked for this law firm. And he had to do family law, and he really didn't like it, and so he got away from it. But back when he was practicing, the rules were different. Then he got away from it, and he comes back in, after the fact, and all the rules are seemingly different because now they have this entire Arizona code. Before, they were relying strictly on the federal rules, which is cool. But then they said, that's a little bit too harsh. Let's adopt the Arizona family code, and it's based off of the federal rules, but not exactly. It's a little bit more casual, let's say. So, but there were real policy reasons behind that. And so his argument was that, hey, now we got rid of Rule 31, which took away the safe harbor, didn't take it away. It imposed a safe harbor. Rule 31 didn't have it. Rule 26 introduced it. But what he failed to realize, and he still fails to realize, is that it's for very specific reasons why you would file under Rule 26. Look, in full disclosure, Woodnick has done a fantastic job in this case. He's done a marvelous job. He won the big trial. He destroyed Jingris about as badly as you could destroy an opponent on the other side in a family court case. He secured a $150,000 judgment for attorney fees and costs against lawyer Owens for his client, Clayton Echard. But for the life of me, I have no idea why he decided to file this petition under Rule 26. Maybe he didn't understand that it triggered this safe harbor provision. But one of the things that Woodnick argued during the proceedings, one of the issues that the judge was contemplating was, all right, well, maybe he was aware that he wasn't in compliance with this Rule 26 safe harbor provision, and then he just realized, you know what, it doesn't matter because there's 3 other statutes that I'm asking for these fees from, and I could just rely on those. And you know what? They don't have these safe harbor provisions. Matter of fact, one of them explicitly states, upon a finding of this, you shall impose fees, sanctions, whatever. And so he withdrew it. And then one of the questions that Judge Mata had was, can I impose Rule 26 sanctions sua sponte if they withdraw the petition on the court's own motion? And she just decided, you know what, doesn't even matter. It's withdrawn. We'll proceed under the other 3 statutes. That's what they did. One of the most relevant question in the appeal, based on what I read, based on the Appellate decision that they authored, was whether or not the 3 statutes in question mirrored that of Rule 26. Because Jingris is right. If they mirrored Rule 26, I think the rule is, if you have 2 competing rules and there's 3 statutes versus this 1 statute, if they're basically for the same thing, then we're going to go with the simplest one. In most federal cases, that means that Rule 26 or Rule 11 would win, and then the safe harbor provisions would apply. That was the biggest question on appeal. But Jingris isn't even arguing it that way. And I'm confused why he's not arguing that way, because it's his best argument is that, look, the Rule 25 attorney fees and costs that were granted should have been brought under Rule 26 because it's largely a mirror of Rule 26. And you can't get around safe harbor provisions of Rule 26 by bringing them under the statute. The problem with that is I don't think the judges are going to agree with that, but it's Jingris's best argument. I have not seen him make that argument, but that seems to be the argument to make. But let's take a look. So the 3, Rule 26 addresses specifically sanctions for improper filings. Like there's no factual basis to bring this claim, or there's something inherently wrong. So withdraw this yourself, or else. The sanctions that were awarded were under 25-324, 25-415, and then of course 25-809, all Rule 25 sanctions. 25-14 authorizes sanctions for specific litigation misconduct. Meaning it's not that, hey, you brought this and you knew there was nothing going on. It's for litigation misconduct, meaning how you behaved during the litigation. That's patently different from Rule 26, completely separate, and it has no safe harbor provision. So the logical fallacy that Jingris, in stating that, hey, so it was too complicated before, so we introduced the family code, Arizona Family Code in 2003 or whenever it was. We had this Rule 31 sanction. It was replaced with Rule 26. The main difference between 31 and 26 is 26 introduces safe harbor. 31 did not. Yet the question was that the appellate courts has, does Rule 26 supersede all statutory Arizona code bases for sanctions, attorney fees, and cost, or otherwise? And the answer that the appellate court came up with is, no, it doesn't. What they didn't do, well, there's some things that they didn't address, but what they're largely stating is that these sanctions that were awarded are separate and independent for Rule 26. I can't even get into the question of whether or not safe harbor applies because Rule 26 wasn't even an issue. They brought it up, it was withdrawn, and we proceeded under these other 3 statutes, that were known at the time of filing back in August of 2023. So 25415 punishes litigation misconduct, such as if a party knowingly presents a false claim in certain family law proceedings or violates a court order compelling disclosure or discovery. The court shall, it's a mandatory sanction, meaning we have to, there is no safe harbor, shall sanction that party by ordering them to pay the other side's costs and fees. That's what it is. And in the Owens case, Judge Mata found that Owens had knowingly presented a false claim and knowingly violated a court order compelling disclosure, triggering 25415. That was for conduct that she had engaged in while the litigation was taking place. There is no safe harbor for that. Matter of fact, sanctions are mandatory in that case. I can't explain why Woodnick filed the request under Rule 26. I have no logical reason why he did that. But it makes sense why he withdrew it. Because why? Look, what am I doing this for? What we're really trying to punish is her conduct during the litigation. She's been under the gun for these 3 statutes since August. Why don't we just proceed with those? And then he did. And so, I don't know. All I'm saying is that the appellate court, once they get to this issue, that 2514 is independent from Rule 26, that they're punishing different things, then the question is dead. Which is why the court didn't even touch the merits of Jingris's Rule 26 argument. Didn't. That was one. The Court of Appeals, they emphasized that the trial judge found that specific, her knowingly advancing these claims, her knowingly violating court orders, basically her behavior in general. And Judge Mata lists a number of different reasons. They emphasize that kind of egregious misconduct is exactly the kind of thing that is contemplated by 25415 and is unique to 25415 and is not contained within Rule 26. They're different. Jingris could have made an argument that they're the same. He should have made an argument that they were the same. It just doesn't work. That's honestly his best argument. Aren't we kind of punishing the same thing here? Rule 26 says you can't bring a complaint based on false information, false evidence, whatever, false claims, safe harbor, and all of that. The difference is that if you get into litigation and you behave in such a way that you're continuously adding onto your petition, filing these egregious motions, violating court orders, advancing false narratives in the course of the litigation, and a respondent to those claims runs up fees and costs, attorney fees and costs, then you are protected under 2514 or 15, separate from Rule 26. Maybe that wasn't the case back in 2003, but they clearly made a policy decision to change it because it was punishing litigants. How in the F are they supposed to know that rule? He claims that Woodnick doesn't even know that rule. He claims that a lot of people don't know that rule because they're federal rules or whatever. I don't know. But they don't know that rule because you don't practice family law that way. It's just there's no benefit to having unexperienced litigants who are representing themselves in these high conflict, highly emotional cases try to abide by all of these weird procedural federal rules that make no sense. The court should have a mechanism to punish bad behavior. 25415 is one of them. And notice how when they adopted Rule 26 with its inherent safe harbor provisions, they did not rid themselves of their inherent ability to punish bad behavior. These statutes remain on the books, and these statutes do not in any way reference Rule 26. They're completely independent of Rule 26. They have no safe harbor requirements, and they exist on their own. There was 25809. That's specific to paternity cases. That likewise permits a court to order a party to pay a reasonable amount to the other party for costs and attorney fees after considering both parties' finances and the reasonableness of their positions. That language largely mirrors 25324, and in this case, Echard invoked 25809G as an additional basis for fees in the paternity actions, and the Court of Appeals noted that the issue was properly before the court because Edwards cited it specifically, like in his response. In sum, the Court of the Appeals had to answer one question. Was Rule 26, the invocation of Rule 26, even if it was withdrawn, did that have the effect of erasing any other statutory mechanism to award attorney fees and costs in this case? The appellate court said, no, it does not. And the reasoning was that the statutory remedies, they serve different purposes. 25-324, 809G, those are specifically fee-shifting provisions. In other words, like, look, yeah, good for you. You brought this case in bad faith. Rule 26, withdraw it or else. But if you get all the way down the road and you're having to defend yourself in litigation and you're incurring these attorney fees and costs, it would be a ridiculously illogical result to suggest that you cannot impose fee-shifting sanctions on the party that's engaging in the bad behavior. That's absurd. And insofar as Echard incurred $150,000 of attorney fees fighting this Miss Owens in court, then he was properly awarded these attorney fees under the provisions, the statutory provisions, which he applied for, 25-415, 809G, and I forget the other one, 324, I think it was. And so that's really it. In other words, safe harbor, really, I mean, it's a thing, but it would have been a thing like, put it this way. If there was notice that, look, you just filed this paternity case. I know that you're not pregnant. You know that you're not pregnant. I demand that you withdraw this otherwise or else, whatever. Rule 26, you give notice, sure, safe harbor, 10 business days, whatever, fine. Echard didn't do that. And at the time, he was in pro per. He probably wouldn't have known to do that. Instead, he did a really good job of invoking these other three statutes that gave him a similar remedy. And they progressed throughout this litigation. They raised a Rule 26 issue at some point, and they withdrew it because it didn't matter. It was whatever. Judge Amata doesn't even really touch it because it didn't matter. This appellate court doesn't even really touch it because it doesn't matter. These statutes, and really what the Arizona courts are saying is these statutes stand on their own for judges in their discretion upon the pleas of any aggrieved party to file a motion and make an argument that this behavior should amount to punishment under 2514 or 25324 or 809G or whatever. Because I've spent all of this money having to defend myself, which is what Echard essentially did. And the appellate courts agree. So that's where we're at. That's where we're at. The courts went so far as to say that Owens' Rule 26 argument was not grounded in law or fact, meaning he did not make the proper argument that he needed to make. He needed to demonstrate how the courts were required in Maricopa County, in this family law case, to disregard Rule 25 sanctions in favor of Rule 26 sanctions upon the invocation of Rule 26. That's not what he did. All he did was say that, look, Rule 26 was invoked when they filed a petition. She should have been allowed to withdraw her petition. It doesn't matter that they withdrew their petition. Safe harbor should still apply. But he failed to connect the dots about how Rule 26 affects Rule 25, if at all, because those appear to be standalone statutes that are specifically designed for family law purposes to protect against outrageous litigation conduct, such as faking a twin pregnancy, faking an ultrasound, lying under oath, all of the things. So there's that. In closing, what do I have to say about all of this? I think that, look, I had some sympathy for Jingris when I watched his video. I thought he was very forthcoming and stating that, look, I used to be in family law, but I've been away for a while. Things have changed. Things have changed. I think that he is so caught up in his federal law arguments. He's failing to understand the policy reasons behind the litigation changes that have occurred in Arizona since he left. And in failing to do that, he's handicapping himself in understanding these arguments. And he's trying to quote these cases, and he's accusing Woodnick and Marcus of citing fake case law or whatever, or false law or whatever. I don't know. He's got a lot of nerve stating that. But he did. I don't know, man. The guy has a lot of conviction for this Rule 26 thing. I have to respect the fight, if nothing else. And he can talk shit about me all he wants. I just know that, look, if you're on Jingris's bad side, that's usually a good thing. It just means that you disagreed with him, or you were unwilling to believe that he's like the greatest attorney in the world, or the best litigator, or this whatever. I don't know. He's right. I'm not currently licensed to step into federal court, but this afternoon, if I wanted to, I could pay $150 or $200 or whatever it costs and be licensed and go to court tomorrow. It would be wise of David Gingras not to get into a pissing match over backgrounds with me in this case. All I can tell you about myself is my bar record is clean. I've never been disciplined by my state bar in California. I've also never been convicted of a crime. And so these shots that Jingris takes, they don't bother me. I'm just stating that it's a really bad idea for Jingris to start engaging in those kinds of peccadillos with me, or Rachel Juarez for that matter. He's going to fall short. And so, look, Jingris, I respect the guile. I respect the fight. Your words and your shots against me, or the others that I've heard speak about this case, really mean nothing. I can see logically where you're going with this, but you're even on your own accord kind of answering your own question. You stated that you had lunch with a judge that told you the policy reasons behind the changes that were made, why they ditched the federal rules, because they were too punitive on inexperienced litigants. It made a lot more sense to adopt a family code that aligns with principles that the courts have more ability to punish bad behavior. You said that yourself. I don't understand why you cannot connect the dots now. But this Rule 26, look, your best argument is that Rule 25 sanctions are contained within Rule 26, and therefore they should be viewed as functional equivalents, and therefore safe harbor should apply. You didn't argue that. I'm not sure that you can argue that, but you didn't try. So you argued incorrectly, and you were defeated. And I suspect that, you made the same arguments in your renewed motion to the Arizona Supreme Court. I suspect it's also going to be denied probably fairly quickly. I wonder, however, if you're going to get the opportunity for oral arguments, because I suspect they're going to answer those specific questions. I think that the appellate argument oral arguments, and it would go similarly to how Rachel asked you those very poignant questions, and you could not get off of this like very procedural mindset. At some point, you have to be willing to confront the policy of it all. You have to. And if you're going to argue that way, you have to make the correct arguments. You just haven't done it yet. I don't think that you're an unintelligent guy. I think that you have, you said that this was a passion project of yours. And I respect passion projects. I just think that you're not seeing the forest beyond the trees, man. Sometimes you got a big picture of this stuff. Just take some time off. He's on vacation now, visiting his dad in California. I hope he has a wonderful weekend. But I feel like with all of Gingerbread's guile, I feel like he's just missing the mark with these arguments. It might not be obvious to him, but I seem to have zeroed in with it after looking at these cases for an hour before the appellate courts weighed in, before anybody weighed in. It was just Jingris convincing me, or trying to convince me, that safe harbor was a thing that should defeat Clayton Echard on appeal. I was like, okay, but what about? And then, whatever. And then we got into our little spats. So that is what it is. So Godspeed to you, sir. We'll see how it goes. That is my response to Jingris's video. I hope you all enjoyed. Let me get to, I got one star. What's up, Jules? Almost forgot. Love you, Omar and Tilted fam. Thank you so much for being a member for 7 months. Jules, you got to give me a follow-up to what happened with that case. And good conscience, I've never seen a holding like you showed me before the other. Well, never mind. Anyway, I love you, Jules. And stay safe out there. Have a wonderful weekend. Folks, I got a long day of streaming. I got to prep for a lively stream. I'm going to be doing a mock deposition of Blake Lively, played by Anita, the internet sleuth. That's coming up. I got some thoughts on the amicus brief that was submitted. I understand there's now been an opposition, but I wanted to give my thoughts on that. Also, of course, we're going to be doing Flad tonight at 5 p.m. Pacific Standard Time. That's going to have the usual cast and crew, Bruce, Brad, Schnitzel, Anita, and we'll see how that goes. Folks, I love you all, and we will see you all in about an hour and 10 minutes. Bye-bye.